Hello and welcome to another week of How to Write a Tax-Efficient Will with Deborah Bowers. Today we shall be discussing how divorce affects your will. Now, divorce is something which is very distressing to many people. I have been through one myself and I know exactly how stressful going through that process is, how heartbreaking it is, and it causes us to reflect on our lives and to see where we go from there, to try to determine where am I going to go from here? How is this situation going to affect me going forward? And some of the questions which people have been asking are, can my ex-partner still be my executor? The fact that I'm divorced, will this revoke my will? Can I appoint a guardian for my children who is not my ex-partner? And can I prevent my ex-partner or my assets from going to the children of my ex-partner and his new wife? Because sometimes your ex-partner has moved on, he has got a new family, so he had children with you, and now he's moved on, he's had children with another person, and so your child has got half siblings somewhere else. And you would like to know, well, is it possible that my child inherits from me and then something happens to my child and all the assets go over to my ex-partner and his children? So today we'll be looking at some of these very taxing questions, which are quite genuine and quite reasonable in the world that we live in, and things which you are to consider if you wish to protect your interest. So before we proceed, I need to let you know a little more about myself. I am Deborah Bowers. I'm a STEP certified advanced will writer. I'm also a solicitor of England and Wales. I'm a GDPR practitioner, certified in CIPPE and CIPM, which is a certificate in European data protection law and a certificate in data protection management. I'm also the author of How to Write a Tax-Efficient Will, which is available on Amazon. It's in its second edition right now. The first edition is in red, it's written out in red. The cover is in red, but this edition is in gold, which is the second edition. Both books are still valid and up to date, but the second edition includes information on lasting powers of attorney, because this was something that many people were concerned about, and I wanted to address it as well. I've got to give you a disclaimer. This is a discussion, so it's not going to form a lawyer-client relationship between me and you. It should not be taken as financial advice or legal advice, investment advice, or tax advice. If you wish to have any of those specific forms of advice, you will need to speak with someone who is certified to give you that form of advice. But right now, this is a discussion, and I shall try to convey to you the best information that I'm aware of. You may also be aware of information and places where you might be able to look to help you research whatever you are interested in. So as we said earlier, the topic for today is what happens to my will if I become divorced, or if I am divorced. And when you become divorced, there are so many things which go through your mind. And I will repeat some of them here again. Will my divorce revoke my will? This is a question that people ask themselves. Can my ex-partner still be my executor because you had him as your executor? Or if you haven't written the will yet, you're thinking, can you still make him your executor? Or you're thinking, oh my goodness, this person has moved on, they have kids, now my child has half siblings. Will my assets end up with my ex-partner's children because now they are her siblings, or his or her siblings? So we shall be addressing some of those issues which cause people concern, and genuinely and rightfully so. So let's deal with the first matter. Will my divorce revoke my will? And as you can see here, it's a big no. So if you had a will before the divorce and you become divorced, it does not revoke the will. The will is still a valid will, but there are things that you need to look out for, and we shall discuss some of these as we go along. So the second issue that we are going to discuss is, can my ex-husband still be my executor? You're just divorced, you're thinking about writing a will, and can you still appoint him or her or she as an executor? I'm taking it from the female perspective because I'm a female doing this presentation. So I'm saying, can my ex-husband still be my executor? The question in this question is one that it all depends. If you have divorced and you are writing out your will, and you put in that will a contrary intention, then you can still have your ex-partner be your executor. But it must be stated clearly in your will that despite the divorce, so you are fully aware that you are no longer together, you are fully aware that it is your ex, because some people, they divorce and they're still on very good terms with each other. Some people, they divorce and it's a complete nightmare. They don't talk to each other. They have absolutely nothing to do with each other. If it is the position that you're on good terms, you still trust each other, you divorced for other reasons, apart from the person being responsible and being willing to carry out those duties that you are giving to them, and you still being able to trust them in that respect, then yes, if you state clearly in your will that you are aware that there has been a divorce, but you still wish your ex-husband or partner to be your executor, then you can do that. However, in the general scheme of things, once you are divorced, and if that person had been the executor before, then the law assumes that that person no longer exists. So a divorce causes the ex-partner to be treated as if they had died. Okay, this is why you need to put this contrary intention in the new will you are writing to insist that this person, you want them to be your executor. But if it had been a will that you had written before the divorce, the law would assume that this person is dead, this person doesn't exist, erased from reality, and so they will not be able to act as your executor. I hope that's very clear. So if the will was written before the divorce, the law assumes that this person does not exist and that that appointment fails. They cannot be your executor. If you write the will after the divorce and you state clearly that you still want this person to be your executor, despite your full knowledge of the divorce, you have created in the will what is called a contrary intention, and so the law will uphold your wishes that your ex-partner can still be your executor. So let's look now at, can I still give a gift to my ex-partner or his wife or husband, whichever way it goes, or his or her spouse? And the answer is yes. You can still give a gift to your ex-partner or his spouse or her spouse. You can, but you must then, and here again, you must express a clear intention to do this despite the end of your marriage to that person. If this intention is not clear, then the gift will fail. So once again, if the will was written before the divorce took place, it will be assumed that this gift is going to fail. These people do not exist, and the law will not honor that gift. But if you write the will after the divorce, and you clearly state that, yes, you wish to give a gift to your ex-partner and his spouse, then once you state that clear intention with full knowledge that a divorce has taken place, yes, the courts will and the law will allow you to give that gift to your ex-partner and even to his or her spouse. So the key here is a clear intention, stating a clear intention in your will that you wish to make that gift despite the divorce having taken place. Can I appoint a guardian for my children other than my ex-partner? Now, this is one that's a bit tricky because we must remember that the ex-partner is the other parent of the child. And so the law will always lean towards giving that parent the right to have the child, because he or she is the biological parent of the child. However, there are certain circumstances when the law will lean against that. And so, although you can appoint a guardian for the child who is other than your ex-partner, you must appreciate that the person who will have the first right of recourse to the child is the ex-partner. But you can say, should you become the sole surviving parent of this child, then I appoint X, Y, and Z as a guardian, a legal guardian for the child. Also, in the event that, for example, the ex-partner has given up their parental responsibility, or the ex-partner is incarcerated, that person is in prison, that person is on drugs, that person is not considered to be competent or capable to look after a child, you can also appoint a guardian other than the ex-partner. So this will be a matter where if the ex-partner now wants that child, the ex-partner will need to go to court, show that they've cleaned up their acts, that they are a capable parent, and they will have parental responsibility. But sometimes, you know, the courts have taken away parental responsibility from a parent. And in cases of that nature, certainly you can appoint someone other than the ex-partner as the legal guardian. So you can appoint someone, but it all depends on the circumstances of the case, whether or not the ex-partner will take priority or the person you have appointed will take priority. Another question which has been of great concern to people is, can my assets end up passing to the children of my ex-partner who are the half-siblings of my child? So we know that sometimes when people divorce, sometimes they've already had children with you and they move on and they have children with someone else. And suddenly you have a family where there are two mothers, different, one father has fathered those two children. So they are brothers and sisters. They are siblings. Now, for that to happen, there are certain things which must occur to enable this to ever happen. Firstly, your child would have to inherit your assets, number one. Your child would have to pass or die without issue, number two. And your child either writes a will, if the child becomes an adult, giving all your assets to those half-siblings, or alternatively, Your child passes without a will, and your child also at the same time has no children, and your child also has no living parents. So a number of things would have to come together to enable your assets to pass to the half siblings. And if the child has passed, that there is no will, there is no living parent, the assets now start passing to uncles and aunts. The assets then might end up passing to siblings, you know, so it would have, all these things would have to come together in one event to cause your assets to pass to the half siblings. You can do what is possible to prevent this from happening by firstly writing a will, passing your assets to your child, but indicating that if your child should die without any issue, the assets would come back to you and to your line and to your descendants. So then it should be either come back to your trustees to be distributed amongst your siblings or your nieces and nephews, or how you want them, or passing the assets simply to your line, your biological line, from you to your child, from your child to their child. And if that doesn't happen, it comes back to your line. So there are things that you can do to assist you to prevent these unpleasant circumstances from arising. So having discussed all of the above, my encouragement to you is to really just take care of each other. You know, we all go through a cycle of life. We start as babes, we become teenagers, then we become adults. Then we've got to think of paying our bills, taking on our responsibilities, and then we become elderly, and then we are no more. If you have enjoyed that full circle of life, then the least you can do is get your house in order, write a will, put in order a lasting power of attorney. And so when you are no longer there, things can run smoothly because you have put in all the paperwork. You have done all the paperwork so that whoever comes after you can rely on that paperwork and things can go in the direction that you intended it to go in and not become a messy muddle of confusion. Okay, so we've come to the end of our presentation now. And today I just want to encourage you that as we move from this year into next year, consider giving the gift of knowledge. And the book, How to Write a Tax Efficient Will, is a perfect gift for any family. It's written in really simple terms. It has lots of examples of wills. It is only $14.99. Hopefully it will not break the bank, although I know that these are challenging times for many people. And it is quite easy to obtain from Amazon. So amazon.co.uk, please get your copy. And if you have any questions whatsoever, you can watch the video in the replay and put your questions in the chat. I always look at the comments so that I can respond to them. Alternatively, you can send me an email at deborahbowerswillwriting@gmail.com. So it's deborahbowerswillwriting@gmail.com. So I wish you the very best, and I hope I've been able to answer all your questions about how divorce affects your will. Unless we have any questions in the chat, I will stop the recording. Thank you and have a good evening. Bye-bye.